Welcome to the law offices of Sabrina Li. If you have ever been quickly removed from the US after a short trip abroad and face a years-long entry ban, this video may help you.
Sabrina is a certified immigration law specialist. Only 1% of attorneys in the US can earn this recognition. If you are in a similar situation, please call 213-375-8096 to schedule a consultation with us.
Our client, a highly skilled professional, had spent over a decade building his life in the United States through lawful immigration pathways, including F1 student status and later H-1B employment. He was a husband and father to a U.S. citizen child, with an established career and stable family life. In April 2024, he traveled briefly to Mexico for a business trip, expecting a routine return. Instead, upon attempting to re-enter through Texas, he was stopped by CBP officers. Within hours, his visas were revoked, and he was placed into expedited removal process. He was issued a removal order under INA Section 235(b)(1) and removed from the United States the same day. What should have been a short trip turned into an immediate and life-altering separation from his family. Many non-immigrant visa holders, including those on H-1B, F1, and B1/B2 visas, assume that maintaining valid status in the United States guarantees smooth re-entry. In reality, each entry is treated as a new application for admission, and CBP has broad discretion to deny entry, even for long-term visa holders. Expedited removal is one of the most severe enforcement tools available at the border. It allows CBP to remove an individual without a hearing before an immigration judge, based solely on a determination of inadmissibility at the port of entry. For H-1B, F1, and B1/B2 visa holders, this often arises when visas are revoked, when there are concerns about prior conduct such as arrests, or when CBP concludes that the individual is not in possession of valid entry documents at the time of admission. In this case, although our client had previously held valid H-1B and B1/B2 visas, those visas were revoked due to a pending criminal matter. As a result, CBP determined that he was not in possession of a valid entry document and charged him under INA Section 212(a)(7)(a)(i). The consequences were immediate and severe. Our client was not only removed from the United States but also subjected to a 5-year bar from re-entry, requiring special permission before he could lawfully return. His wife remained in the United States, unable to work, while caring for their young U.S. citizen child. The sudden separation created significant emotional and financial hardship for the entire family, particularly given that our client had been the primary provider. Although expedited removal is often seen as the end of the road, that is not always the case. In this situation, we took a strategic approach by filing a Form I-212, which allows individuals with a prior removal order to request permission to return to the United States. Instead of focusing only on the removal itself, we carefully reframed the case to highlight what truly mattered. We clarified the nature of the issue at the border in a way that placed it in the proper legal context, helping USCIS see that this was not a case involving fraud or intentional wrongdoing, but rather a situation that required a more nuanced review. At the same time, we focused on presenting a complete and credible picture of the client's background, his long-term lawful presence in the United States, his professional career, and his role as the primary provider for his family. We also documented the immediate and ongoing impact of his removal on his spouse and U.S. citizen child, including financial disruption and emotional strain. By combining legal precision with a carefully structured presentation of the facts, we were able to turn a highly challenging expedited removal case into one with a viable path forward. Through a comprehensive legal and evidentiary submission, we secured approval of the I-212 waiver. This approval removes the legal barrier created by the expedited removal order and clears the path for our client to pursue re-entry to the United States through the appropriate visa process. This case highlights an increasingly common but often misunderstood risk. Even highly skilled professionals on valid non-immigrant visas, such as H-1B, F1, or B1/B2, can face expedited removal at the border based on issues that arise during inspection. A single incident, such as a visa revocation or unresolved legal matter, can lead to immediate removal without court review and trigger years of separation from family and disruption to career. However, with the right legal strategy, these cases can still be successfully resolved and a path forward can be created.
If you or someone you know has been affected by a similar situation, contact the law offices of Sabrina Li at 213-375-8096 or email us at info@sabrinali.law.
Our legal team will do everything in our power to handle your case. Your American dream, our commitment.